All parties on Cherry versus Keller. Step forward, please.
30-year-old railroad agent Timothy Cherry claims 40-year-old railroad engineer Leroy Keller assaulted him over a parked car that blocked his. Leroy is countersuing for his 30-day job suspension and attorney fees.
Order. All rise. Yeah, this is case number 697 on the calendar in the matter of Cherry versus Keller. Parties have been sworn in, Judge. You may be seated.
You both work for the railroad, is that right?
That's correct.
Yes. And you had this big brouhaha over parked cars. Foolish, right? Foolish. So, Mr. Cherry, why don't you start from the beginning and tell me why you believe Mr. Keller owes you all this money? $3,000 with a counterclaim for another $3,000.
On July the 18th, we have a mail contract to work for the railroad. I was up in the mail car, attending to my duties when Mr. Keller approached me. He was very upset that he couldn't get out from where I was parked.
He couldn't get out?
He couldn't get out of his
parking space because of your car?
Because of where I was parked.
Okay.
Mr. Keller approached me, and his exact words to me were, "Give me your keys, or I'll bust your windows out and ram your car." I turned to the person I was working with at the time, and I told him, well, let me go down and move my car out of his way. As I went to get down out of the car, as soon as I touched the ground, Mr. Keller ran over to me and went to grab me in my chest. I pushed his hands off of me, and I told him not to touch me again and that I would be back. You know, I told the people I was working with I would be back. Let me go and move my car. All the way up the platform over to the garage, Mr. Keller's making shoulder contact with me. He's bumping me, telling me, "Who do you think you are? You have no reason to block me in, and you knew this was my car." I had no idea whose car it was. It was an area where all the employees park. If it happens to where we block each other in, we simply just come and ask to move. Once we got out to the garage, I went to open my door, to let him out. He had went over to his car. Before I could get the key good out of my door, he rushed over to me and pushed me to the side of my car. At that point, I didn't know what he was going to do. He had been to his car. He was back over there. He had pushed me for the second time. I went to my trunk. I actually ran to my trunk, opened my trunk, and removed a baseball bat. By the time I came from the rear of my car, Mr. Keller was on his way back to his car. He started revving his engine. He started moving his car forward like he was going to ram my car. And by the time I backed up enough for him to get out, he actually did make contact, but it didn't cause any damage at that point. He left the garage. I immediately picked up the phone and called 911. As I'm on the phone with the 911 operator, Mr. Keller enters the garage again from the other direction. He gets out of his car and approaches me, reaching for my phone. I have pictures of the damage that was done to my car.
Well, I thought you said there was no damage done to your car.
The damage that happened to my car was a result of him shoving me to the side. When he shoved me to the side, it was this elbow, I guess, that caused the damage.
When did he shove you to the side?
When I went to take my key out of my lock, he came rushing over to me at my car and pushed me to the side. He got inside of my car, released my emergency brake, and started pushing my car backwards.
Let me see the alleged damage to your car, sir.
Sure. Those are pictures. I have a light-colored car. It's kind of hard to see it, but I tried to take it from an angle where you could see the indentures.
It's very hard to see.
I also have an estimate, Judge, where
Let me see it.
That particular place was estimated.
Although I'm having difficulty seeing it, clearly the place where you took your car in to be repaired from where you claim that he came over and pushed you, you have a bill for $526.42. Okay, Mr. Keller.
Judge, I would like to show a diagram of the parking lot in the car incident. This shows the train this was where Mr. Cherry was located working on the train. I came into work that morning about 7:30 a.m. after being on duty for 14 straight hours with nothing to eat. I went from this location here to my car, which was parked here, and as you can see, Mr. Cherry's car has me pinned in between a concrete wall and two other cars. I walked from this location through this door to the ticket window, and I asked the ticket agent, I said, there's a Mazda 626 parked out here, and I gave him the license plate number. I said, could you make an announcement? I thought maybe there was a passenger waiting to pick up someone that had just parked there and would be there for temporary time. The ticket agent, he said, I know whose car that is. That's Mr. Cherry. He works here. I said, well, could you get a hold of him and have him move the car? I'd like to go home. He went outside to look, and he said Mr. Cherry was way down at the end of the platform here working on the train. I said, okay. I said, I'm going to call the parking lot and find out if there is a policy of double parking here.
But there are a lot of other cars that are double parked.
There was one other car double parked.
Well, I see that. So what did you do, sir?
So I went in and I talked to the security. They said it was a matter that they couldn't handle. So then they suggested calling the police and calling a tow truck. And the tow truck said that he could not tow a car unless he had permission from the police, and the car had to be parked there for 48 hours.
Okay. First you found out the car belonged to Mr. Cherry. So how long did that take? How many minutes?
Probably about 10 minutes.
Okay. And then you were still at that location when you called the tow truck?
Yes.
A tow truck. Did you have to get a number of a tow truck?
Yes, out of the yellow pages.
Okay, so you had to get the yellow pages, look up a tow truck, and call a tow truck. And about how long did that take?
Another 5 minutes.
So that's 15 minutes. Did you call the police?
I spoke to the dispatcher, and they said that there was nothing they could do.
That took another 10 minutes?
No.
How
just
long?
A couple minutes.
Another 5 minutes?
Yeah.
Okay. So now we're up to about 20 minutes.
Yes.
Right? And then you decided yourself to walk over to where Mr. Cherry was working.
Yes.
And how long, sir, did it take you to get from the ticket window where you were over to where Mr. Cherry was?
About 3 or 4 minutes.
Judge Judy continues in a moment.
I said, are you crazy? I said, do you realize what you're doing here? He says, look, you're lucky I don't get my gun out of my trunk and kill you.
Real cases, real people. Judge Judy. Railroad agent Timothy Cherry is suing railroad engineer Leroy Keller for assault after Timothy blocked his car.
So my first question to you is, sir, instead of calling a tow truck, which took 10 minutes, calling the police, which took another 5 minutes, 15 minutes, why didn't you just take a 3-minute walk over to where he was and say, why don't you move your car?
Mr. Cherry and I have had an interaction before.
What kind of an interaction did you have before?
One evening about 11:30 p.m., I was on my way to work and I was coming into the parking lot. There is a stop sign that's displayed because there's a bad intersection. I stopped at the stop sign. Mr. Cherry drove around me at a high rate of speed to get to his parking spot. And I said to him, I said, did you know there was a stop sign back there? And he said, I'm from St. Louis. We don't stop at stop signs.
So,
with that attitude, I figured there's no sense talking to a gentleman.
So you didn't
like
say anything to him?
No, I didn't.
No, okay. So then you walked over there.
Yes.
What happened when you got over to him?
When I got over to him, I said, do you own a Mazda 626? He said, yes. I said, well, you're blocking me. I said, I'd like for you to move the car.
Is that the way you said it, sir?
Yes.
You sure about that?
Yes. He said, I'll move it when I get done with my work.
Or the middle?
And I said to him, I said, I have been delayed long enough. I would like to go home. I've been up for 14 hours, and I would like to go home. He said, I'll take care of it when I get done with my work. Once again, I suggested to him, I said, just give me your keys. I'll move your car for you, and I'll leave the keys at the ticket window. He threw his gloves down, and he started getting upset, cussing at me, and telling me that he wasn't going to give me his MF keys. He jumped out of this train car, and instead of climbing down the ladder, he tried to jump on top of me. And with my natural reactions of him coming out on top of me, I pushed to keep him away from me. Once he got down on the platform, then he started chest butting me around. And I told him, I said, look, I said, I don't have time for this. I want to go home. So we walked from the train back through the depot. I went through the first door in the depot from the train station, through this door and to my car. Mr. Cherry went back into the baggage room through the employee's room, and he stayed back there another 5 minutes before he came out of there. I sat in my car waiting for him. When he finally showed up, when he come through this door and he came out here, instead of getting directly in his car and initiating the move directly, he stood by his car with his arms folded and just grinned at me. So when he came over to his car, he put his keys in his door, unlocked his door, opened up his door, got into his car, sat in his car, and looked at me again. Then he got out of his car and he went to the trunk. So I went over to look. I looked inside the car. I noticed it was a manual shift car. I popped it in neutral and I put my shoulder on the doorpost and give it a push back. As I was pushing the car back with my door on the doorpost, when I looked up, Mr. Cherry has a baseball bat and he was taking a swing at me. I said, "Are you crazy?" I said, "Do you realize what you're doing here?" He says, "Look, you're lucky I don't get my gun out of my trunk and kill you." And I said, "That's it."
Hey.
I said, "That's it." I got in my car. By that time, I had pushed it back myself. I got in my car. As I was leaving, I looked in my rearview mirror, and yes, he did have his cell phone out, and I figured, he's calling the police. I'm going to be in trouble if I leave the location. I pick up my cell phone in my car. I call the police. The dispatcher says, "Yeah, we have an altercation down at the Amtrak station." I said, "I think I'm involved in that." I said, "Would you like me to return to the location?" "Yes, that would probably be the best thing to do." So I returned to the location. After talking to the police, they tried to resolve the situation, and they talked to us, and they explained to us that either one of us would file charges against each other. We're going to end up in jail that day. The officer told me, he said, "If you go up to him and you just shake his hand and apologize to him and say, 'Let's forget this,' we'll let it go." So I went up to him and I extended my hand, I shook my hand, and the officer said, "Go on, we'll take care of it." So a few days later, about 3 days later, my supervisor calls me and he asked me about this situation. The company decides to hold a formal investigation. Through the formal investigation, the facts were gathered that both of us were at fault.
Responsible.
That's correct.
And they docked you both a month's pay?
They fired us both for 30 days.
Okay. That's your cross complaint. You want the amount of money that you lost for being fired for 30 days. That's what you say here.
What I'm having a problem with is, after 30 days of being disciplined, Mr. Cherry files an assault report with the police. I have to go hire an attorney to represent me in this case. It cost me $700. The prosecuting attorney dropped the case due to lack of evidence on the police report. That wasn't good enough for Mr. Cherry. Now Mr. Cherry is filing a claim against me in small claims court. I feel that, if anything, I'm entitled to the lawyer's fees that I've had to pay for purely out of harassment on Mr. Cherry's part of trying to get even with me.
Judge Judy continues in a moment.
He actually had his hands firmly put on my chest, Judge,
All right,
and I
Mr.
removed
Cherry,
them off of
you're not a wimp, are you? You're not a wimp. You weren't injured. He overreacted.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Railroad agent Timothy Cherry is suing railroad engineer Leroy Keller for assault. Leroy is countersuing for lost wages and attorney fees that resulted from the fight.
Let me tell you, I've heard your side of the story, and I've heard your side of the story. Each of the stories flavored and colored a little bit to suit your own purposes. So let me tell you what I think happened. I think as far as the parking and blocking his car is concerned, Mr. Cherry, that was absolutely the wrong thing to do. You never know if you block somebody's car, whether it's for 5 minutes, 10 minutes, or an hour, or 2 hours, that say nothing. That there may be an emergency, somebody has to get their car out right away, and it's very irritating, especially when you're at some distance from where you have inconvenienced somebody. So I don't blame him for getting angry. Now, the fact that you had a history before suggests to me, Mr. Keller, that you were not as calm as you present yourself here today. I do not believe that after you spent 15 to 20 minutes trying to get even with him by having his car towed away by the police rather than walking 3 minutes over to where he was working to tell him to move his car, that you were happy with him, that you walked up to him and said, "Could you please move your car? I'd like to get out." That is inconsistent with human nature, and it's inconsistent with male testosterone. It just doesn't happen that way, Mr. Keller. So that he doesn't know what's happening, all of a sudden you come up, you've had a little tiff before, and you start screaming at him to move his car, and probably used a couple of expletives in the process. Then Mr. Cherry gets irritated, and he's going to take a walk back to help you move your car, but he's going to take his sweet time about doing it. So he's sitting in the car, burning and stewing. Now, I absolutely think that he was 100% wrong to go into your car and move it physically. Now, what I want to know from you, Mr. Cherry, is once this was all over, sir, and you had your disciplinary proceeding, and you all went through getting laid off for a month and lost wages over this nonsense, why did you file assault charges against him?
By him grabbing me in my chest, he made threats not only to me, but to my vehicle. When I got to my vehicle, Mr. Keller continued with his threats.
It's a little overreacting, Mr. Cherry.
He actually had his hands firmly put on my chest, Judge,
All right,
and I
Mr.
removed
Cherry,
them off of
you're
him.
not a wimp, are you? You're not a wimp. You weren't injured. He overreacted.
I have
He
sworn testimonies, Your Honor.
overreacted, sir. He overreacted. You know, I'm not going to give him an award or a testimonial dinner for his loud mouth, for his bad attitude, for doing the wrong thing, I think, judgment-wise, about your car. But there comes a point where you have to put a period and say, all right, this is enough. We both suffered from this incident. It was the wrong thing.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Mr. Keller, I believe, sir, that you overreacted to this situation. You got good and mad. I can imagine that. You've seen people in a parking lot waiting to get their car out for 3 minutes, and they get crazy if they want to get out of a parking spot and somebody is blocking them. So, Mr. Cherry, I am giving you the money to fix your car. I think that you both got hot under the collar. Both of you. However, you had out of pocket that you can establish to me to fix your car, and I assume that you're fixing your car, sir? $526. As far as your counterclaim is concerned, Mr. Keller, I believe that in this instance, if I were to indicate that one person was the aggressor, in this case, it would be you. He may have known how to push your buttons, but once your button is pushed, that's your responsibility. And you did certain things that I could tell that somebody who was only very, very angry would do. Take control over somebody else's vehicle because they're not moving fast enough to push it away manually is something that somebody would only do if their testosterone level was up to their eyes. So judgment for the plaintiff in the amount of $526. The counterclaim is dismissed. That's all.
Parties are excused. You may step out.
Judge Judy continues in a moment.
Parties on Taylor versus Sadlaka. Step forward, please.
38-year-old attorney Suzanne Taylor is suing 45-year-old property manager Peter Sadlaka for fees for an eviction case. He's countersuing for the loss of his building.
Order. All rise. Quiet, please. Your Honor, this is case number 665 on the calendar in the matter of Taylor versus Sadlaka. Parties have been sworn in, Judge. You may be seated.
Ms. Taylor, you're an attorney.
Yes, Your Honor.
This is a suit against a former client of yours for non-payment of a legal fee that had been part of a retainer agreement. Is that right?
That's correct, yes.
Can I see the retainer agreement, please?
It's a retainer with the signature.
All right, so you signed this retainer agreement?
Yes, ma'am.
And for what period of time did you represent the defendant?
I represented him from March 10th of '98 was our first meeting, and on August 7th, I told him I would not represent him anymore.
What kind of proceeding was this?
It was a commercial eviction. He's the owner of property. There's a bar on the premises, and he was trying to evict the tenant.
Why did you tell him that you would no longer represent him?
Mr. Sheindlin was very difficult to represent. The first action we brought, when he came to my office, he already had an action underway, and he had gone to court and said that no rent had been paid, when in fact the rent had been paid to his lawyer prior to the court date.
So he had a prior lawyer?
Yes.
Is that correct, sir?
Yes, ma'am.
Go ahead.
After that, I served a notice. I reviewed his documents regarding the lease and the documents that he gave me, and I served a notice on his tenant, noting all the violations of the terms of the lease. And after 20 days, we were to bring an eviction action. By the time we got to court, he had accepted rent, which after you terminate a tenancy, accepting rent begins a new tenancy. So again, we had to go and apologize to the judge and say that we could not go forward with the proceeding.
Did you explain to him that he couldn't accept rent?
I explained to him when he told me he had received and accepted rent, but he didn't ask me at the time he received it what he should do. Instead, he asked a friend of his, and his friend gave him the advice to accept the rent.
Now, when did you find out that he had had a prior lawyer who accepted rent for him?
When he came into my office on March 10th.
How many lawyers have you had in the last 2 years?
Ms. Taylor and my first lawyer.
Are you telling me that in the last 2 years, with regards to any action that you have had on this property, you only had 2 lawyers?
That's correct.
All right, when did you buy this property?
I sold it in August of '94
You sold it to whom?
to my tenants.
You sold it in 1994. What were you suing them for rent for in '98?
They breached the contract, and I wanted to evict them. And I actually got an eviction granted on March 4th. The judge says, eviction granted. Then they came up with a show cause order for me. Well, I had all the goods on them. I said, let's go. Well, the second time around, I said, well, maybe I ought to take a lawyer on and go and see the judge the second time around, because all I got is a formality here. On March 16th, after confiding in Ms. Taylor, we went to court. And we stood there like we are right now. I'm in a situation with all this evidence in front of me. My tenant's landlord and Ms. Taylor walk up to the judge. They did a little bit of whispering, et cetera, et cetera, et cetera. And then she walked back out of me and says, we have to leave now. This confused me a lot, because I just wanted to be heard and have the judge decide what the problem.
Had you accepted rent just prior to your going into court on that occasion with Ms. Taylor?
No.
Are you telling me, sir, that from the time you went into Ms. Taylor's office, when you first retained her, to the time you appeared before the judge that you've just described to me, you accepted no rent from the tenant?
No, but what I...
Who did?
I did on March 4th, not on March 16th.
No. Listen to me carefully.
Yes.
So the answer to my question is, on March 4th, you accepted rent from your tenant.
Correct.
Shut, just listen.
Yes.
And on March 16th, you went to court with Ms. Taylor. Is that right?
That is correct.
When you accepted the rent on March 4th from your tenant, did you consult Ms. Taylor prior to you accepting the rent?
I didn't know her then.
Your Honor, he did have another attorney at that time.
Did you consult your other attorney?
No, because he didn't. He wrote me a letter that said that he was dropping my case after not taking care of the business at hand.
Just a second.
Okay.
Did you, prior to March 16th, notify Ms. Taylor that you had accepted rent?
Yes.
When?
When I saw her. I don't remember what date we sat down and talked, but I did tell her this.
Ms. Taylor, did he ever tell you prior to you going to court that he accepted rent?
He told me after he'd already gone in front of the judge on his own and asked for an eviction based on non-payment, and we went in on the 16th to sort of make reparations and apologize to the judge.
That you could not go forward.
That's correct.
You owe her money. Period. End of discussion.
Well, that might
You
be
owe
so,
her
Your
money.
Honor. But that might be so. But there still is the fact that I was breached 6 different times, and all I wanted to do is have the judge look at the situation as it existed and cast a judgment on the contract that I had that said they should have been evicted by the contract that was written, not what could have happened.
Mr. Sidlaka, let me tell you something. There are a lot of lawyers in the United States of America. I know a lot of lawyers who practice. There are very, very few lawyers that tell a client to go take a hike, that we don't want to represent you anymore. Lawyers are used to dealing with difficult clients.
Judge Judy continues in a moment.
So if you don't like what the judge did, file a complaint. They'll take your complaint, they'll throw it in the garbage.
And later today,
Madam, this is a court. Courts deal with contracts, verbal contracts or written contracts, not what you feel.
real cases, real people. Judge Judy. Attorney Suzanne Taylor is suing property manager Peter Sedlaka for her fees for an eviction case.
What I'm hearing today is that your first lawyer discharged you as a client. That's what you told me.
Yes.
And your second lawyer discharged you as a client.
Yes.
I can understand why. You owe her the money. Now, she sent you a bill for $1,000. You have an item, you have an accounting form?
I have the invoice that I sent on August 7th
Let me
when
see
I
it.
discharged him. Since then, it's been interest and collection costs, which are under the retainer agreement.
You received this?
Well, yes, I did.
Good. Did you ever, in writing, question any of the charges here?
For Ms. Taylor?
Yes.
No.
Good.
But I definitely did question the judge not speaking to me. This whole thing could have been settled. When I stood in front of the judge, he said, look, you don't have enough here, even though you got 5 different counts on these people for eviction. Sorry, you can't do it. We stood in front of that judge and we walked out that day. I was not satisfied.
Well, whether you're satisfied or not, that has nothing to do with your paying her.
Oh, I
Judge,
don't mind paying her.
Good!
But that does not negate the fact that I was not I had no due process of law in the
Write a
courtroom
letter to
itself.
Dear Abby, sir. Let me tell you something. Judges don't necessarily hear litigants individually when they're represented by counsel. When I have an attorney before me who's representing somebody and the client opens their mouth and wants to speak, I say to them, sir or madam, you have the following choices. Either you discharge your attorney, in such case you are appearing pro se and I will listen to you. Otherwise, whatever you have to say to me, you say to me through your lawyer.
True.
So if you don't like what the judge did, file a complaint. They'll take your complaint, they'll throw it in the garbage. This lady you're going to pay. And this nonsense counterclaim that because of her mishandling of your case, you lost your building,
Well,
is
that's
nonsense.
True. It isn't nonsense, sir.
Of course
ma'am.
it is.
Well, then none of the
Of course it is.
None of these breaches count then. All these
Just
breaches.
a second.
Yes.
You had 2 lawyers. 2.
True. I'm not. Look, the lawyers. If the judge had just told me that.
This has nothing to do with the judge. The judge isn't on trial here,
No,
sir.
he is. No, he isn't.
That's
but had he
right.
just listened to the breaches that were concerned here, he could have seen that these people should have been gone.
Shoulda, woulda, coulda. He didn't want to hear him that day because you had accepted rent. And once you accept rent, the eviction
I
proceeding
only
is over. Judgment for the plaintiff in the amount of $1,000. That's all.
Parties are excused. You may step out.
All right, no problem.
The fact of the matter is that he sold the building, and he regretted that later, and he was trying to find a way to undo it.
They tell me now that because it's all past the water under the bridge, I can't do it any longer. Only one shot at the brass ring, right?
And now the next case.
Parties on Medeiros versus Roden. Step forward, please.
Bowling League member Julie Medeiros says substitute bowler Wayman Roden owes her half the money won in a Las Vegas tournament. Wayman claims they had no agreement to split the winnings.
You 2 folks are in a bowling league. Is that right?
Yes.
According to your complaint, there is a tournament, a big tournament held in Las Vegas. Mm-hmm. And for personal reasons, you were unable to go. Is that right?
Considering not going, yes.
You were unable to go. the defendant went in your place, you said you had an agreement with him that should the team win, you would receive half of the winnings.
I made an agreement that no matter what the team wins, I get half of the winnings.
Fine. Team won. He refused to give you half the winnings.
True.
Okay. And your defense is what, sir?
Basically what she said, except that I didn't agree to give her half of anything. I agreed to share the winnings with her. But
That's
she's
what you
claiming that everything that I received is winnings, and even the IRS will let you deduct your out-of-pocket expenses before they ask for their share.
So what your defense is that you did agree to share the winnings with her.
Right.
But that you had certain out-of-pocket expenses, and some of your out-of-pocket expenses were what you put into the league.
Right.
How much exactly did each team member win?
We received $550 each.
What you say you should be getting $225.
550, I should be getting.
Why?
Pardon
Yeah,
me?
Well, just a second. Now, my question to you is, why, if the team won $550, you don't dispute that,
No.
and given the best case scenario for you, that he agreed to give you half the winnings, that's $225. So I don't understand why you are suing him for $525.
Yeah, I'm suing him for $525 because everyone puts into the league throughout the year. And at the end of the season, each person puts in $250 towards their trip there.
Right.
Okay, so I'm out of pocket there, $250.
But he didn't agree to give you that.
No, he didn't. And the only
just a
reason that
second.
I asked for it
Yeah.
was because he then didn't agree to give me what we had verbally agreed upon. So I also asked for the $250, what I was out of pocket, letting
But there was
him
no
go,
agree- but just a
letting
second,
him
but
go
there
in my
was-
place.
I'm speaking. Madam, this is a court. Courts deal with contracts, verbal contracts or written contracts. Not what you feel, but verbal or written contracts. You had no agreement with him if he went in your place to cover what you had put into the league up until the time of the tournament.
That was not our agreement, no.
It was not your agreement, so you
No.
can't sue on it. What are you suing on?
That's what I was asking for.
Well, I just want you to understand
Right.
why I would not consider it, because it's foolishness. It's what a court is. Court deals with contracts. So it's $275.
Judge Judy continues in a moment.
You got a bargain, Mr. Roden, for your $120. For your $120, you got 2 nights stay, and you got 2 meals a day, including 2 banquets. So don't give me nonsense about your $120 when you contributed half of what everybody but 2 people did to go to the league.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Bowling League member Julie Medeiros is suing substitute bowler Wayman Roden for half the money won in a Las Vegas tournament.
Now, why shouldn't I give her $275?
Because I didn't win $550.
What did you win?
I won $171.
How did you win $171?
I received $550, but I had out-of-pocket expense.
What out-of-pocket expense?
I paid $128 into the league.
Just a minute. Well, so did she. So what? The $128 into the league, sir, listen to me. According to her, each person contributes so much towards going to the tournament.
Right.
Is that right?
Right.
And that's what your $120 was. Right? Going towards going.
It goes into
Listen
the
to me.
prize fund.
Whatever it is. She contributed $250. Put your hand down. She contributed $250. You
Right.
contributed $120. Did you have to contribute any more than the $120?
I didn't have to.
Good. So that she contributed $250, and based at least in part on the fact that she contributed the $250, you were able to go. Is that right?
No.
Yes, sir.
Stop. Listen to me. Listen to me. Does every team member, pay attention, does every team member contribute $250
No.
for the privilege of going through the course of the year.
No.
They contribute different amounts?
Yes.
Based on what?
You pay a certain amount each week that you bowl.
Right, but that has to, are you telling me, Mr. Roden, that every member of the league contributes different amounts?
Okay, I subbed for 3 different people, and I paid into the league during that time. I asked the secretary, how many games do I have to bowl to be eligible to go? She said, you have to bowl 45 games.
Just a second. Are you from the league? Is that
Yes.
you look like you have something to say? Step up here, please. I just have a few questions for you. Tell me your name.
My name's Robin Sloan.
Miss Sloan, how many people are there in this league?
56.
And do you take care of the finances for this? How many people actually go to Las Vegas from your league for the tournament?
56.
And what amount does everybody put into this general fund in order to go?
$250.
No.
Per person.
No way.
Raymond was a sub in the league. He's
Yes.
an alternate.
Right.
So he didn't have a guaranteed spot to go. He was just trying to get enough games in to be eligible to go. He didn't pay $250 into the league, but Julie did, and so did all the other 55 bowlers.
Okay. Now, was he the only sub?
No.
There were other subs. How many?
Yes.
One other.
Okay.
And how much money did he get?
I
Talk-
didn't
Hey.
have arrangement with Cecil, sorry.
Mr. Roden,
Yes.
you're wrong, sir. You're wrong. Now, this $250, what does it go for?
It goes for the hotel, food, and their tournament expense.
Okay. So the hotel, and how many days do you stay at the hotel?
2 nights and 3 days.
Okay. Do you share a room with
Yes,
someone?
it's double occupancy.
Okay. And it pays for a meal allowance?
You get 2 meals, 2 dinner banquets, and then you have 2 brunches.
Okay. And that's what this $250 is for?
Right.
Is that right?
Yes.
You got a bargain, Mr. Roden. Okay. For your $120. For your $120, you got 2 nights stay, and you got 2 meals a day, including 2 banquets. So don't give me nonsense about your $120 when you contributed half of what everybody but 2 people did to go to the league. So what other out-of-pocket expenses did you have?
To get there and back. It's 1,100 miles from my house to Las Vegas.
So who dragged you?
No one.
Good. You didn't have an arrangement with her when you said to her, I'll share the expenses with you. You didn't say, I'll share the expenses with you and deduct from the expenses that I will share with you my gas and wear and tear on my
I didn't
car.
tell her a percentage of anything either. Not 50% or not 1%. I just said I would share
Well, then,
and do what was
just a
right.
second. Shh. Are you speaking out?
No.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Well, Mr. Roden, then, based upon what she says, you said you would give her half. Based upon what you say, you will share the winnings with her. So that, let us assume that I believe you. Then that leaves up to the court, not to you, what I believe is fair.
That's right.
Good. And I believe that anything other than a 50% split would be arbitrary, because I could say it could be 40%, it could be 33%. That would be arbitrary of me. Right? If I were to say to you, Mr. Roden, what do you think a fair allocation is, then you would say 30% or 25%, and you would be rewriting this agreement. So somebody has to rewrite the agreement, because you did, according to you, have an agreement to share.
That's correct.
I believe share means 50%. Judgment for the plaintiff, $275. That's all.
Parties are excused. You may step out.
Judge Judy continues.
All parties on Patterson versus Robinson. Step forward, please.
27-year-old child support officer Merica Patterson is suing 22-year-old Annette Robinson and her husband Richard Scott, 40, for scratching her car as Merica picked up her child.
Order. All rise. Your Honor, this is case number 642 on the calendar in the matter of Patterson versus Robinson. Parties have been sworn in, Judge. You may be seated.
Who are you?
The plaintiff.
Well, you're the plaintiff because the car that was allegedly damaged was your car, is that right?
Yes.
But you don't know anything about this. You weren't there.
I wasn't there when.
So why don't you have a seat?
Okay.
Miss Patterson, this gentleman is your former husband, is that correct?
That's correct.
How long have you been divorced?
Since 96.
And you have one child together?
Correct.
How old is that child?
My son is 4.
And you are his present fiancé.
Yes.
Well, in this unfortunate situation, the basics of it are that you went to pick up your son from a period of visitation at their house.
That's correct.
And there was an altercation between you and Miss Robinson. You claim that during that altercation, she damaged your car. Is that right?
That's correct.
Okay. So Sunday at 8 o'clock, you arrived to pick him up, and what happened?
Instead of my son coming down, Annette came down and she...
This is Annette.
Correct. And she came to my car and she had my son's boot with her. And I asked where my son was, and she says, I want to talk to you first. And she laid across my car like this, holding the boot. And she kept telling me that I was going to talk to her. I was not going to get my son until I talked to her. She would give me this boot back now and give me back the other one when she received Drew's Nikes back. And
Drew's Nikes, you mean his sneakers?
Correct. And I just didn't want to go through all this. I just wanted to get my child and leave. They have a locked door on their apartment, so I can't, I have to sit down there and wait for them to bring my child out. And instead of my child being down there, she came down.
So your complaint says that she scratched the roof of your car with this boot.
Correct.
Let me see the damage to your car. So there's a long scratch on the car.
Correct.
One scratch. Is that right? Okay. Miss Robinson, do you mind telling me what you were doing coming down to talk to her?
Mrs. Patterson has made an issue about all the clothing that Andrew wears. So what I did is I just simply went down there to talk to her. She had accused me of giving away Andrew's shoes to their child.
When did she accuse you of giving away his clothes?
Earlier that week. She had called me and asked me where his other shoe was, and I said I'm looking for it. He threw it when he was taking off his shoes and get ready for a bath. So I told him I was still looking for his other shoe, and just give me a minute, just give me some time, and I'll find the other one.
What else was there in the conversation?
That was it.
Well, that she didn't accuse you of giving away his clothes.
She asked me, well, I think you gave it away to Nellie, which is another little girl Andrew currently plays with and talks a lot about.
Did you ever say that to her?
No, the only reason that got brought up, I asked her about it, is because my son came home saying that Nellie wore his shoes home. So I asked her about that.
So the mother comes to pick up the child after a period of visitation, and you go down there with one shoe. Mm-hmm. Now, what was the purpose of going down there with the one shoe?
Letting her know that the other one was lost. I was very genuine about letting her know. I'm very serious.
The other one of this was a pair?
Yeah.
So why didn't you just come downstairs, or why didn't you go downstairs with your son to keep this very calm?
Well, for one thing, I didn't want to get Drew in the middle of an argument because
she wouldn't have been an argument.
She makes an issue out of everything, Your Honor. Everything, and I try to keep Andrew out of it. So
good. Then she should have kept Andrew out of it, and you go downstairs and talk to your ex-wife. I mean, had you been friendly with each other before this incident?
No.
Listen, tell me about the shoe. I don't see how this shoe could have caused the scratches to your car, madam. I really don't.
Okay, I don't know if the shoe does have the eyelets on it and stuff, but I don't know if maybe there was a rock in the bottom of the shoe at the time, or the fact that she does have a big, bulky watch that she wears, and that she was laying across my car like this. So not that it's just that the fact that she did have the shoe in her hand, and that's what was of her body was touching the car, was her arms and the shoe. And she was waving her arms across the top of the car and pounding the shoe on top of my car, telling me that I was not going to get my son until I discussed this issue with her.
Look, there was a big problem about clothes, because I read your answer very carefully. Mm-hmm. I read it, and I didn't like it. I didn't like it because originally, according to your answer, you were going to drop off little boy at his mother's house. Is that right? Mm-hmm. On that day? Wasn't that your plan?
That's what started, yes.
And then you decided not to do it because of this clothes problem. That's what it says here. Mm-hmm. Right? Mm-hmm. We had second thoughts about returning Andrew directly to their house, though, because he was wearing clothes Rick and I bought. Marcia had made a big issue about these clothes often failing to return to us, the ones that we sent. So we decided it would be best to send Andrew home in the clothes that his mother sent him over in. So that means that this little 4-year-old boy comes back from wherever you had him out for the day, and you say you have to get out of those clothes. You have to put on your mommy clothes. These are your daddy clothes. You got to put on your mommy clothes. Is that what you're telling me? Come on. What you're doing by saying that to him is, this is not a nice thing between my mother and my father. They make me change my shoes and my socks and my underwear and my clothes in order to go back to my mother. Don't you see that there's something wrong with that?
Yes, I do.
So why do you do it?
This has been going on for a while. We've been sending them over in clothes and never said anything. We've not gotten any of the clothes back. Or when she sends them back over, they're not even in half the clothes we even sent over. I've never seen them again.
Let me ask you this question, sir. Does she have another 4-year-old child in her house?
No.
So whatever clothes you buy for your son, he's wearing.
Right.
He may be wearing them to school. He may be wearing them out to play. Now, he also, I'm going to ask you one other question. He doesn't come to your house for the start of visitation naked, right?
No, he comes in clothes that are almost 2 sizes too small for him. I mean, I can't even take him to the store after I pick him up. I have to take him home and change him first.
He doesn't come to your house naked.
No, he doesn't.
Okay. So what difference does it make?
Judge Judy will continue in a moment.
Annette, butt out.
And later today,
Now, you got some heck of a nerve to give her $15 Christmas time on a $3,000 debt.
real cases, real people. Judge Judy. Marika Patterson claims her former husband's fiancée, Annette Robinson, scratched her car when she picked up her child.
You see, just so that you'll recognize this, first wives and second wives don't get along. That's just the way it is. They could be both lovely people. It's the rare case where the first wife and the second wife get along, and the only time that that usually happens is when they both hate the husband. That's just the way life is. So you don't send your fiancé down to do your bidding because it's just dumb and counterproductive.
I didn't send her down, Your Honor. She made that choice to go down.
Well, that was ridiculous. And it shouldn't happen again. Because if you return Andrew to his mother when she's been agitated by something that your fiancé does, who do you think's going to suffer? You're supposed to try to alleviate whatever stressors you can. This is a stressor. Now, you may not be able to alleviate the stressors that exist between the two of you, although that's really dumb, because if he wasn't a great guy for you, maybe a great guy for this lady, but he wasn't great for you. You have a nice new husband? You happy?
Yeah.
Terrific. He's going to have a nice new wife. He's going to be happy. Terrific. You happen to have a child together that's going to tie you together for the next 30 years probably, or more. So you try to get along.
We didn't have any problems for a long time until she came along and started trying to maneuver and instigate and make decisions and do things. We really didn't have a problem between the both of us.
The main reason that Annette kind of took over on some of the things is because whenever I would take Andrew down with me, she would chew on me right in front of Andrew.
That
So I
is
didn't want that.
unacceptable. Listen to me. When the child is there, nobody is to say anything negative or that would precipitate an argument. Hello, how are you? Did you have a nice time? Thank you very much. I'd like to speak to you. Give me a buzz later in the house. Period. And when you take the call, take it and make sure that Andrew isn't around. Both of you. It's as simple as that. You should have absolutely no reason to have any negative conversation with him.
When I go to pick him up, I don't talk to them at all. I just take my son and leave. It's when she comes down to the car and my child's not there, I don't have a choice. I don't wish to speak
Has
with
this
him.
happened before?
With Annette coming down to my car, yes, this happened 2 other times that she came down to my car and they held my son in the apartment.
For what reason?
So I would talk to her about whatever issues they felt were issues at the time.
Annette, butt out. It's none of your business. Zero. You have no business getting yourself involved and injecting yourself into their life. Absolutely none. Listen to me. Don't be a wimp. Don't send her down to do your work. To send this lady, seems like a nice lady, down to do your job, understanding the premise that I started with today was first wives and second wives usually don't get along, is a very foolish thing to do and not good for your son. And certainly not over clothes. It's not such a big deal. I mean, I don't know whether you send him over in clothes that are not of good quality. If you're doing it to be a little spiteful and to give him a dig, don't do it because it's hurtful to your child. But they're his clothes. They're not your clothes. They're not her clothes. They're his clothes, and he's wearing them. Stop making a big deal about it. This is nonsense. Hey, Miss Patterson, you have another child now. You have a daughter, right? I assume that you would scratch the eyes out of any person who tried to emotionally harm either of your 2 children. Is that right?
That's correct.
And that's the way you should feel as well. When he hears either parent talking badly about the other, even when you're talking to his father on the phone, that does not make him feel good. If you're doing it, stop. That's all.
Parties are excused. You may step out.
America is just jealous of Annette more than anything is what I think it is. She thinks that she's, jealous that maybe Andrew might like her more or something. I'm not sure exactly what it is.
The truth of it being is we take very good care of that child. He don't pay child support. He's over 3 years back behind child support.
And now the next case.
All parties on Bates versus Barkdale. Step forward, please.
Retiree Alga Bates claims 40-year-old waitress Sharon Barkdale owes her over $3,000. Sharon claims Alga is trying to ruin her life.
Miss Bates, according to your complaint, the defendant was a neighbor of yours and became a friend. Is that right?
Yes, Your Honor.
And according to your complaint, she told you that she had some financial problems.
Yes, Your
and
Honor.
that you loaned her, in a series of loans, $3,025. Is that right?
No, Your Honor. We loaned her $3,840, and she paid back $815, which left a balance still to be paid of $3,025.
Thank you. Okay, now, Miss Barkdale, you acknowledge in your answer to her complaint that you borrowed this money.
Yes.
And you say, however, that after you borrowed the money, she became controlling of your life, caused you a lot of stress. Therefore, you are not going to pay her a penny. And in addition, you're countersuing for $5,000 for nuisance, harassment, pain, and suffering. So, Miss Bates, you don't have to say anything. She's acknowledged that she borrowed the money. She's acknowledged that the outstanding amount is $3,025. Is that right?
That's correct.
Judge Judy will continue in a moment.
How dare you have a Christmas party when you still owe her $3,000? You've got some heck of a nerve. I mean, if you're a big girl and you don't want somebody to act like your mother, start growing up.
Closed captioning sponsored in part by Real Cases, Real People, Judge Judy. Alga Bates is suing Sharon Barkdale for the return of over $3,000 in loans.
Okay, now, Miss Barkdale, convince me.
All right. In December, Olga and I were very good friends, and at that time, she had become controlling of my life. She was like a mother figure to me. I felt very close to her, but the more that I felt close to her, the more controlling she became over me. So at that point, I severed the relationship. I felt like she wanted to sever the relationship, and I was still paying her small amounts of money until one day I went to work and she left a message on my machine saying that if I didn't pay her more money, that she was going to have me fired from the Hyatt, or go to the Hyatt, excuse me, not fired, go to the Hyatt and tell my employer that I owed her this money. So I wrote her a letter saying, please don't do that, because if you do that, it's going to cause these problems. Number one, they don't want to hear personal problems. Number two, if you do that, I'll get fired and I won't have a job to pay you back. And number three, here's $15 intent to pay, and let's work through this. So after that happened, I had a Christmas tree in my house, and I had sent out some invitations for a party. I left a cocktail notice on one of the neighbors upstairs, and she went and got it off his door and called him in LA and told him that I was having a cocktail party. She then leaves a recording, 2 different recordings on my answering machine, saying that, oh, you have this big cocktail party, you know, you owe me this money, surely you're not paying for it. Then her husband left a message after that saying, we do not want anything to do with you anymore. So I said, fine, if that's what this is about. So I went and got a restraining order on her, a temporary restraining order, because she was walking past me and saying, oh, there's the girl having the big cocktail Christmas party. And I mean, and it was just ridiculous. It was like all I wanted to do was continue paying her.
Just a minute. Give me the best reason you have for not paying her.
The best reason is I got fired from the Hyatt Hotel, and where am I going to get the money to pay her now?
Did you get fired because of her?
I believe I did.
No. Well, then, if you believe you did, you got fired because of her, why don't you tell me how?
Because she left a message on my machine saying to me, and it was like on a Friday, and she said, if you don't pay me the money that you owe me, I am going to the Hyatt Hotel, and I'm going to tell them that you owe me this money.
Okay.
Judge Judy will continue in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Here we go. A, your countersuit is dismissed. It's nonsense. You don't like the way somebody is talking to you. This is not nuisance, harassment, or anything else. It's somebody who's trying to give you some advice, even though you didn't ask for it. You're a big girl. If you don't like the advice, you don't listen to it and tell her, I don't want to listen to your advice. Don't talk to me anymore. That's not nuisance. That's not harassment. And certainly the only pain and suffering that I see in this case is from these 2 people that lent you money. Now, you got some heck of a nerve to give her $15 Christmas time on a $3,000 debt, $3,000, and then go out and have a party in your house. Big party, little party. You went out and bought invitations. You went out and mailed the invitations. You had a party. You served liquor. You served food. You had to spend at least $100. Can't do a party for less. Right, Bert?
Not doing
that. No. Can't do a party for less. How dare you have a Christmas party when you still owe her $3,000? You got some heck of a nerve. I mean, if you're a big girl and you don't want somebody to act like your mother, start growing up. Judgment in this case is for the plaintiff in the amount of $3,025.
Parties are excused. You may step out.
Judge Judy will continue in a moment.
All parties on Mayhew versus Mayhew. Step forward, please.
28-year-old contractor Sean Mayhew is suing his ex-wife, 21-year-old Amber Mayhew, for back child support for their 3-year-old daughter. Amber is countersuing for utilities.
Order. All rise. Yeah, this is case number 645 on the calendar in the matter of Mayhew versus Mayhew. Parties have been sworn in, Judge. You may be seated. Have a seat, please.
Mr. Mayhew, you and the defendant were married. You are now divorced, and you have custody of the child of the marriage. How old is that child?
3.5.
Boy, girl?
Girl.
Girl. You are suing the defendant for back child support.
Yes, Your Honor.
What does she owe you?
$13.28.
There is a counterclaim here by Ms. Mayhew for some old utility bill.
Correct.
And for some other nonsense. All right, Mr. Mayhew, how long has your daughter been in your custody?
Since she was born, and then when she left in October of 98, 7.
Do you visit with your daughter?
Yes, I do.
Okay. I read in your answer what seemed to be a suggestion that you do owe him money for child support. Is that right?
Yes, the first 2 months. I paid him little bits, $50, $30.
And then you say you've been consistent with your
I
payments
have been
since?
consistent with all of my payments.
Show me.
I have a list here of the time and dates that I paid, and I have a few, I'll let you have it, money order stubs that I have. That's the only receipts. I don't have receipts. I paid him cash the whole year.
Did she pay you cash the whole year, sir?
No, she didn't. I have a breakdown of what she did pay.
And also, here's another one for, I put her in daycare. She's in daycare this month. That's my...
Well, what does your judgment of divorce provide for with regard to payments?
$158 a month.
And it's your testimony that but for the first couple of months you were regular in your payments?
I was supposed to start paying in February. I did not start paying until the middle of March.
No, that's wrong, Your Honor. She didn't start paying until August.
Miss Mayu, you see you have a problem. Let me tell you what your problem is. When somebody sues for back child support, he says you haven't paid. You have some receipts that you did make payments, and he says you did make certain payments. So you are going to have to establish to me that you made these payments, because most people, when they make child support payments, they make payments by check.
I trusted him. I was with him since I was 15 years old. When I left him, I did not have a job. I did not have any direction at all whatsoever. As soon as I did start working full-time, I paid him. She's my daughter. I was an at-home mother with her for 2.5 years. I would not be a loser mom and not pay my child support, period. He is lying. I paid him, period. I have my witness, has been there a few times.
Well, I'll hear your witness.
She also has heard him say that he's going to get me back for anything he can because I messed him up. He wants to, you know, screw me over.
What's your name?
Allison Noah.
Miss Noah, can you recall dates, times, and places where you saw exchanges of cash between the plaintiff and the defendant?
I know for sure on August 3rd, their daughter's birthday, I went to their daughter's birthday party, and I saw her pay him $80 in cash that day.
That's not correct, Your Honor. She never gave me any money on her birthday. Her father, I guess, offered to pay me $60 towards the birthday party, and I refused to take it. I paid for the whole birthday party and everything. She never gave me any cash during that time.
Did you see her?
Yes. I saw
give
her
him
give him
cash?
money, yes.
At any other time did you see him accept cash from her, and in what amounts?
One other time in October, my daughter and I were with her and her daughter, and we were in her car taking her daughter to his house. And she gave him, I saw her take cash up to him. I assumed it was $80 because that's how much.
You didn't know how much it was, but you saw him actually accept money.
Yes.
Do you recall that?
It wasn't cash, it was one of the vouchers that she has up there, one of the receipts, because she was paying at that time.
No, it was cash,
No,
Your Honor.
it's not
It was
here.
cash.
This is not I don't have an October date there. She has 4
And the only reason I don't have
amounts.
receipts is leaving him, divorcing him, I was left with tons of creditors. I did not have a bank account. People were trying to garnish my wages, what little money I was making. I did it out of good faith. I mean, I've known him for, years. I gave him the money,
Mr. Mayu,
yes.
Listen to me, sir. You just testified that you didn't get this payment that she's referring to in October. Is that what you're saying?
Right, I got it in a money order. I got money orders September, October, November, and December, and January. And then my wife served her with the court documents here, and she stopped paying. So I didn't receive anything from this year in February or March.
Ms. Mayu, you say that you missed a couple of months initially.
In 98, the beginning of 98.
Just a second.
Okay.
And other than that, you say you were current.
Yes.
Okay.
Every paycheck I got, he was my first person I paid.
Okay.
And the only reason...
Listen to me. Shh, listen to me. I'm getting somewhere.
Okay.
Did you pay him in January of 99?
Yes.
Did you pay him in February of 99?
Yes.
Show me.
I don't have proof of it.
Now I'm going to tell you why. If you're not honest with me right from the get-go, then you always catch yourself. Because you said to me, other than the first couple of months, I've paid him regularly. Then problems started at the beginning of this year, the beginning of 99. When were you served with a summons for back child support in the family court? In what month?
I'm really not even sure.
You have a witness?
Yes,
Or can
I
you
do.
tell me? Step up, please. You're Ms. Mayhew?
Yes.
When did you serve the defendant with the summons for the family court on the issue of back child support?
In February, early February. I don't have the exact date. We filed on February 1st.
Okay.
You served her that night.
And I served her that night, so February 1st.
Okay. Now, one of the problems that I have, Ms. Mayhew, is you did not pay in February at all, and I'm going to tell you why I know that. Because according to the papers that you give me, you show that you have made payments in December, January 19th, 1999, and January 5th, 1999. Okay? So you made 2 payments in January, but clearly you made no payments for February. And did you make any payments thus far in March?
No.
All right. So that clearly there's at least a couple of months that you didn't pay him in September, according to you. Clearly, you made no payments in February, and clearly you made no payments in March.
No.
And you didn't make any payments at the beginning, in September and
No, I did not.
October. Okay. For the first couple of months at least.
The main reason I didn't is he told me he wanted to garnish my wages. That's how it should have been in the beginning. I said, you want money from me? Garnish my wages. Since he's met his new wife, he took, Casey from me. I had her 50% of the time, and after that, it just all went downhill.
Judge Judy will continue in a moment.
Ms. Mayhew, who do you think should provide you with a roof over your head? Except you.
Myself, definitely,
Perfect.
I agree.
So you don't get any medals
All
for that.
right,
That's what
all
you're
right.
supposed to do.
You're right.
Real cases, real people. Judge Judy. Sean Mayhew is suing his ex-wife, Amber Mayhew, for back child support. Amber is countersuing for utilities.
All right.
Your Honor?
Yes.
Okay. I filed through the state to petition to garnish her wages because every time she would come over and make a payment, we would get in a fight.
You don't have to necessarily garnish her salary. That can come if she doesn't pay. Clearly she hasn't paid. They're going to garnish her wages now and have the payments made directly through the court. You don't necessarily have to get her employer involved. If she was paying directly, she could just make the payments through the court.
Right.
So that there would be a record. So that you both learned a very interesting lesson. And the lesson is you're supposed to have receipts, but you owe them a lot of money. Because you owe them a lot of money, taking what you say as true, at least part of it.
I swear to God, Your Honor.
No. Listen to me. Taking what you say is true that we found out today, you haven't paid him for a couple of months when you started. You didn't pay him in February, and you didn't pay him in March. The grand total of that is $1,040. Okay, that's a lot of money. Now let's get to your counterclaim.
Where did you think I'm not paying? Where I missed that.
Where? Don't miss it. Did you give him money in November?
I was not ordered to pay him.
I didn't ask you whether you were
no,
ordered.
I did not. No,
That's
I
not
did
my
not.
question.
No, I did not, Your Honor.
Did you give him money in December of '97?
No, I did not.
January of '98?
No, I did not.
February of '98?
No, I did not.
Well, you mean you just told me a moment ago that you didn't have to be ordered by anybody. You know that you have a responsibility. You wouldn't just be a deadbeat mother. And I'm going to tell you, there's a lot of talk about deadbeat fathers when they leave and they don't pay until they're ordered to pay. You said to me that I wasn't under an order to pay. That doesn't mean you don't pay child support. That doesn't mean you don't say...
I completely agree, Your Honor.
So?
Completely agree.
So stop complaining. How many months did you get away with not sending support until you were ordered?
I didn't get away with not
sending
sending support.
Did they make a retroactive order in the court? Did they make a retroactive order? Well, they should have. If you were before me, you would have gotten a retroactive order from the time you didn't pay. The courts do not differentiate between fathers and mothers with regard to paying child support. Both parents are responsible to pay child support.
Definitely.
If you walk out of a marriage, that's your prerogative, but you can't walk out of your responsibility to support your child. Now let's get to this ridiculous utility bill that you have here that you counterclaim. You say when I split up, he was to take care of the utility bill, and he did not. You want to tell me about that?
Him and his ex-girlfriend, Pam, were living there. She moved in a week, 2 after I moved out.
Show me.
I'm being sued for the amount here. And I asked him for the PGE bill. I'm there now.
Well, show me. What dates? I assume there are dates on that.
There might not be, just the amount.
Well, what am I supposed to do with this? You say it was at a time when they were living there and you were not.
Yeah, I had
Show
taken
me.
myself off the lease. That's all I had. It was an old bill. It was from 97 into 98. It was approximately 3 months worth of PGE, and he was supposed to have put it in his name, and he didn't. And it was my responsibility not turning it off in my name.
Did you pay the utility bills?
Yes, I paid for everything. She had her mail forwarded. I never got a bill for it. I tried to get in contact with her, but the first 2 months,
You never shut it off in your name.
Just a second.
I can't shut the electricity bill off when it's in somebody else's name.
In what month did you put the electric bill in your name?
I think it was January.
Okay. So for the months of October, November, and December,
Right.
it was in her name.
Right.
Okay, and you did not pay those bills because you did not get those bills.
Right.
Is that correct?
That is correct.
All right. Well, then you have to pay the electricity bill that you
Okay.
owe, right?
Right. I can
Good.
understand that to the point.
Perfect.
Except for that, she stuck me with I have to pay for a babysitter because she took off right away on the
Live-in
spur of a moment.
babysitter.
Hey, don't
No.
talk to him. Don't talk to him.
Excuse me, sorry, Your Honor.
So
we don't
I was
offset.
already living check to
Listen,
check.
Listen
so
to me.
And I was living with nothing. Excuse me.
You have to pay for the electric because you use it. You're not going to offset that because of a babysitter. This is your child. Are you happy having your daughter with you?
Oh, yes.
Perfect. And your daughter is fine?
Yes.
Perfect. Let me make some clear suggestions to you folks. I'm giving her credit for the utility bill, which is $350. I am not giving you missed work of $150. That's absolutely ridiculous. You probably caused more missed work for him than I guarantee you this
I
utility
supported a
bill.
two-bedroom apartment all by myself, so taking a
Well,
day
who do you
off
want?
of work was
Who do you-
very intense.
Let me ask Miss Mayhew, who do you think should provide you with a roof over your head, except you?
Myself, definitely,
Perfect.
I agree.
So you don't get any medals
All
for that.
right,
That's what
all
you're
right.
supposed to do.
You're right. Well, I was with him for 5 years, and that was like...
What?
It was a struggle for me. I'm very proud of myself. I'm very honored to say that I take care of a nice two-bedroom apartment and have my own car and pay my own insurance and pay all my own bills, and I'm not depending on anybody, and I still
Well,
pay
that's
him
what
the
you
money.
should be. That's what all people
Definitely,
should be,
but I'm
especially
I'm
women.
proud. What can I say?
Especially women. They should always make
Yeah.
sure that they can take care of themselves.
Judge Judy will continue. And later today,
And what you said to me, and the answer was, this is between brother and sister.
closed captioning sponsored in part by Real Cases, Real People, Judge Judy. Sean Mayhew is suing his ex-wife, Amber Mayhew, for back child support. Amber is countersuing for utilities.
I'm going to make the following suggestion. That any monies that you give him by certified check, by money order, keep a receipt, or by personal check, which you will get back from him. That you do not accept any cash from her, ever. I'm giving you certain credit for the utility bill of $350. I'm offsetting that against what I believe is a reasonable adjustment of the plaintiff's claim for back child support, and I'm awarding you, sir, $700. That's all.
Thank you, Your Honor.
This case basically shows that not all dads are deadbeat dads, and they could be the mother, too.
He said that he was going to do whatever he could to get me back. I screwed him, and he was going to screw me.
Chaos pa mang game start ko. Yung pabila go chasara dagas na rin sa galulor ko. Dito ba ndasebe. Ha, nama number de. Zayo full. So the full shot. The cast number show. Laka na patawa kalki. हाँ दो गिटे पार्ट लकड़ा زما solid شو موټر په پارک کړه زما solid دي نو داسې کار وکړو solid زه غلی مې پاټ کړه زما نمبر شو اوس په داسې کار وکړو سالډز دا ګیټې به پاټ کول دا یوه په قلار به ولو چې واپس ته راونوځي زبردست ورپسې بیا دا یوه صحیح ده स्टापर पीवो बनाना पार्ट शी हाँ उस पर पसी बिया सॉलिड दाना पार्ट की दाला हुआ है पागा पे वो लगे तो पार्ट पे शिकेलेश बच ना बच زبردست خطای کړه زما نمبر دی ښه به داسې کار وکړو باچاجي چې سالډ دغه نه کېږي دا یو پارټ په دغه کېږي زبردست So داسې کار کوو کومه یو بخلي چې دا یو بولږي که نه وبش زبردست ها your solids زما نمبر ته ماته پته اوس خو داسې کار کوو ورته دې سره یو ګوته کومه وشولاله دقه اوس داسې کار دی پیر صاحب چې دغه پارټ شي نه یو بل شی ورسره کوم حقه یې فاول مې وکړو ځه You need to hit. Jacob has ball in hand. Get out. خطای کو ماته کار وکړه دا اوس چټه لګي پلته مشکل ده که پاټ شي پلیته ولګېده Eu gitera tapatira o Josi part kam. Jika has the ball in hand. sama नंबर दिवस मी टाइम बराबर बा आता 11:30 यो स्टॉपर पे पिवा मा स्टॉपर पे ना जबरदस्त रोज मुश्किल लगा ब्लैक पार्ट्स उम्मीद को दे पार्ट पर आवाज नहीं चाहिए oh my god सड़े में जैसा ये बहुत अच्छा दमे पे क्यों ना करो खवता शिकार दे बाचा सलामत जिसम रखो नो सॉलिड बत्ती उल्लू जानो मामा लक्ष्य share my part إذا نشاطه يجت بكيشي إذا part لا pasta shot now دير خطر ورو اسمه دينا تروح ولا تقلده ها नज़र में कड़ा हाँ वस्ता शिकार दे फिर से वो लक्षणता से लक्षण बराबर लक्षण बराबर वाक़ई शेफुरान से माणा लगा तुरो का बेटी खाना था इसलिए درې او دوه لکه ما ته درې پاتې دي ته دوه پاتې دي شیوران دی یار مکه ښځه بیا مې ده چې ریمیچ کوي که نه شاټ کې مونږ چې ته ګټۍ پاټ نه کړه یاره to some car ne še posaki there was call for watch stripes دي اوس په داسې کار وکړو دا بال به راولو او چېرته یې اډ کړو دې کې به یې اډ کړو دې پسې مانا بال نه کړه ټیبل بس वही वो पता है चश्मोदी तकड़ा दे रहा साला चलना जो कम तार के होगा शो आखिर मामा अज़रा और देख किस्मत तबोरा kami kita buat di dua hari nasi kar buku coba buku any time part ki dapat ya awal part ma koi khatna mein kar bachu چشمونی نوی ګټه ما دا نه پټ کېږي دا یو بل به ټرای وکړو اخی واه ایزي چانس مې مس کړ ښه اوس به دلته سره وګورو ټرای پکې ولري خدا اوهو شوه ترونه به ګیم څنګه ګټو مکه زه لږ تیز وکړم شی مې خپلوان کړه یار به یې سره څه لږ یې ښه لیک پال ونه وم نور به کېږي ګټه یې بلاک شي که نه بس ورسره زبردست اوس به ګورو ځان مې ډېر یقین نشته خو زه ټرای کوم مکه اخی نه ښه قسمت دی چې بس اوس پر آسان ګیم وګټي او که نه ماته پته وه نه بس ته زه نه